Apolitical support across the House, and I support the bill.
Mr Speaker.
Honourable Phil Goff.
Mr Speaker, it was interesting just to pick up on the comment made by the last speaker about welcoming bipartisan support. I think it is good when the House can come together and overwhelmingly support a piece of legislation that people acknowledge will improve the functioning of the justice system. And indeed, the Law Society, in its submissions on this bill, made the point that in regard to criminal legislation, you should try to take the politicising of it out and actually work to have a coherent policy that will serve the interests of New Zealanders, of victims, and all of those that who appear in the court system. And I would hope that the Honourable Kate Wilkinson and the National Caucus as a whole would actually take those principles and apply them more generally to the legislation in the House. Because last night, Mr Speaker, we spent hours debating legislation where no member of the National Party got to their feet to debate it, that were rammed through under urgency. No attempt was made to build consensus. There was an absolute politicisation of the process, and then they wondered why they got powerful government security legislation rammed through in the House with the barest of margins. So I say to Kate Wilkinson, take the principles that you've just stated now and apply that to what you are generally doing across the House, and then you would get better legislation. You would have proper process and you would have good legislation. What the National Party showed last night is that it was not interested in process and was not interested in good legislation. It was not interested in protecting human rights against the most intrusive powers that the state can operate. Now contrast that with this legislation. Suddenly peace and harmony, Chester Borrows, is broken out across the House. And there's good reason for that. Look, I agree with what Chester Borrows said in the House last night. This is the most important changes to the criminal procedure legislation in 50 years, in a couple of generations. And we need to look at the process to understand why actually this legislation will be good. It began under Labor, actually, in 2007. And the way we went about this, and I was Minister of Justice just prior to that, the way we went about it is we got the Ministry of Justice to do the work together with the Law Commission, and they spent thousands of hours in working out how we could get fundamental reform to deal with some of the issues that confronted the justice system. So the process it wasn't rushed, it wasn't rammed through, it wasn't designed to be a distraction from the embarrassment of the government in another area like the GCSB legislation was last night. It was proper process. The homework was done, the groundwork was laid. And then we got the legislation. The primary legislation for this bill, Mr Speaker, was 526 pages long. It was an enormous piece of legislation. And what it tried to do was to address some of the critical issues that were facing the procedures in the criminal justice system. There was excessive costs. There were excessive time delays. You had a legislation process or a framework that was outdated, and you had excessive complexity involved in it. In fact, the Law Commission described the court system as an impenetrable maze for lawyers. Now, lawyers might like that because it creates work for them, but actually, when they think of the public interest, they don't like that. And you've got to think about serving society, about serving victims, about protecting the interests of defendants in the right way. We were getting huge delays in the court system, and justice delayed is justice denied. We've heard that many times over, and it is absolutely correct. So the legislation that came in basically aimed at addressing these critical problems: excessive cost, excessive delay, excessive complexity, and an outdated legislative framework. Now, there was cross-party support for that broad reform, but then the government decided they wanted to put in a number of more contentious things. That included lifting the threshold for jury trials, so you wouldn't be eligible for a jury trial unless your jail sentence, maximum jail sentence, was in excess of 3 years. They required the defence to identify and disclose issues in dispute, under dispute before trial, and that clearly would have worked against the interests of the defendant and would have been unfair. There was a requirement, or there was the allowance of courts to actually try a defendant in the defendant's absence. That was an absolute turnaround on fundamental rights in the justice system that go back hundreds of years. There was the attempt to load compliance costs onto those involved in the process, and there was the attempt to remove the right to silence. Now, I want to give credit to a past National Minister of Justice. Actually, even though he put this in the original criminal procedures legislation, when the submissions were heard before the Select Committee, the evidence was given, and Labor and the Greens and other parties highlighted the inadequacies of this. Simon Power listened and made changes. He listened and he made changes. There was proper process. The Select Committee worked. That's what democracy was about. And that's why last night in this House we fought tooth and nail against the abridging of that process and the truncating of the opportunities for people to make submissions. Because if you want to get legislation right, this legislation demonstrates absolutely clearly the importance of the Select Committee process. And we've just heard national members on this technical piece of legislation to bring the criminal procedures legislation into effect, saying how important those submissions were. Today they say how important it is for the public to be able to make submissions. Last night they voted in the House to abridge the right of New Zealanders to have their voices heard on perhaps the most intrusive powers a government has ever given itself to interfere in the privacy of individuals and to direct companies. Now, I say, Mr. Speaker, that is double standards. We can't say this legislation is good, isn't it great, we've got consensus, good process, good outcome, and then do the opposite. And I ask, when is this slow-to-learn government ever going to pick up the message that if you want legislation that serves New Zealand properly, then you do the proper process. You consult before you bring in contentious legislation. You try to embrace the opposition and say, this is what we're trying to do. Before you tell telecom companies what they do in every aspect of their jobs, talk to them first. Talk to them first. Because we saw in the corrections amendment legislation that some of my colleagues on the opposite side of the House were on the committee. The government in that case didn't talk to the telecoms companies first. They got it absolutely wrong. They had to do a total U-turn. But did they learn that lesson, Mr. Speaker? No, they did not learn that lesson. And the appalling thing about today is that this bill before us today highlights every rort, every inadequacy, every breach of process, every attempt to truncate the ability of New Zealanders to have their voice heard and people to be properly consulted that occurred last night. When is this national government going to learn? When are those backbenchers with their heads down now actually going to stop being lobby fodder and challenge in their caucus the ridiculous decisions being made by their ministers, including the Prime Minister? Because people elected you to the House, the government members to the House, actually to have their voice heard, not to stand up on highly contentious legislation, mumble some inane comment and sit down. That is not the job of the government backbenchers. And well, you should hang your heads in shame at the behaviour of the National Party caucus and its acolytes last night in the House. Mr. Speaker, this piece of legislation is actually a good piece of legislation. It supports a piece of legislation that had bipartisan support, that went through proper process, and we are celebrating that now. So for heaven's sake, if this is good, and this was good process, and this worked in the interests of New Zealanders, apply those same principles across everything that the government is trying to do, including some of the obnoxious pieces of legislation that were compelled through the House last night by the narrowest of majorities. All that means, Mr Speaker, is actually we'll be back in 18 months under a new government to repeal that legislation. This legislation today is an example of how you should have done it, and that's why Labor is supporting it.
Dr Jackie Blue.
Thank you.